Hey guys, thanks for watching again. This is Jerry Mason, the Kickin lawyer. Today we're going to talk about a topic that I am fast, hopefully becoming the attorney of choice in the area on, and that's DUIs. Now, this is going to be a series of videos, this is the plan anyway, on specific sections of DUI defense that I think are important to consider individually and maybe give a little more attention to. This is slightly out of order. This is the first one for the series, but it's going to deal with implied consent. And the reason it's out of order is there have been some new developments in the law that I think are relevant and that kind of need to be voiced now to give everyone, including law enforcement. If you're a cop, you really need to pay attention to this because there are DAs in the area even that, I'm not talking about our specific DAs, but I know in some of the jurisdictions I've been to, the DAs weren't even aware of some of these changes that do affect whether or not your DUIs are gonna hold. So anyway, the first step is so first of all, let me give you a little background. So most states, and again, keep in mind I'm talking about Tennessee is my area that I'm licensed in, but most states do have some form of implied consent law. What is implied consent? Basically, in the context of DUIs, implied consent deals with the inference that just because you are operating on the public roadways by virtue of operating on the public roadways of the state, that you have then consented that if a police officer or representative of the state comes up and has probable cause to believe you're operating a vehicle under the influence of some intoxicant, alcohol and or drug or what have you, that you have given your consent, implied consent, for them to do a breath or blood test, okay? So there have been a few changes recently that are very interesting on how it affects implied consent. Now, why is it a big deal? In the context of DUI defense, it's a really big deal. And the reason is implied consent violations, if you say you don't give blood, so they read you the implied consent thing, they do whatever, you don't give blood, you don't blow, you don't give them any other evidence. You could beat the DUI later, but lose on the implied consent. So they could hit you with a license suspension for the implied consent violation, even if you're found not guilty or the DUI is dismissed. So you're penalized even though you ultimately are found not guilty of the offense. Now in Tennessee, the implied consent statute is really sort of a civil penalty. The final adjudication on it is in General Sessions Court, and so that carries more issues. So real quick, reason why is if you hire an attorney in Tennessee, a lot of times in criminal court, it's to handle the initial first setting or first appearance level, which is in General Sessions typically, or your local city court. From there, if you do a preliminary hearing or whatnot, that's going to be the final adjudication on the implied consent. So let's say you lose the preliminary hearing, which is common in, if you watch my other videos, I explain that with the defense law because the burden of proof is so low, it's probable cause. But let's say you lose that. Well, then you get hit with a license suspension for the implied consent violation. Now, the DUI is still pending. So even though you lose the preliminary hearing, the DUI charge goes over to Tennessee Circuit Court, which is trial court. But in sessions, you're already penalized for this incident, even though you're not convicted yet. So the reason that's bad is that then you got a license suspension, and you go over in circuit court, and you might lose again on the DUI and get another license suspension. Or, almost worse, you beat the DUI at trial or whatever after you paid us all this money, and then you still had your license suspended for a year because of the implied consent violation. So to me, it's double dipping. I've had great problems with this at the beginning of doing this criminal defense stuff. Now, I don't want to undermine the importance of the DUI offenses. You know, there's some people that just don't need to be driving. And obviously the main way to not get arrested or in trouble for DUI is just don't drink and drive. But there are cases I've had where the client, I think, legitimately wasn't drinking and driving. For whatever reason, they got pulled over and accused of it, and then have all these penalties that come after them, and they're really innocent of the offense. I know it's hard for people to believe, but it is possible for innocent people to be arrested for these offenses. Regardless, you know, the DUI is a misdemeanor offense in most states, at least in Tennessee it is, and it carries such stigma and penalty with it. That's why a lot of people, like me included, are carving sort of a niche out of practice of just doing DUI defense. So anyway, that's sort of a broad overview of how implied consent can affect you. There's penalties, you can be fined, they take your license, all this kind of stuff. Plus, if you do submit and you didn't really want to, and they get this evidence, they can use it against you. So the breath can be used against you, and it's not completely accurate. And same thing with the blood evidence can be used against you. And there's ways to fight that in court too, and I'll have videos on that coming up. But it's just more hurdles for you to jump, and more fees. You got to pay a lawyer or an expert witness to help defeat it. Again, it can all be offset if you didn't have to do this implied consent deal. So that's the way it initially was. Now, a few defenses real quick. So here's how we line those up. So one is, and this is without the big changes to the law I'm going to tell you in a minute, right? And that's the key to this video. If you're a cop, you need to watch to the end, because the law that I'm going to outline is case law that's changed the statutory spectrum. And that's why a lot of jurisdictions in this area have changed the way they're prosecuting DUIs and specifically implied consent violations. So anyway, defense number one, the consent, right? So you have to be able to give consent. So let's say that they've done all the procedural stuff properly, read it to you right, you got to give consent. Well, maybe you're drunk. If you're really inebriated, it might be hard to give legal consent, because you're so drunk. So intoxication is almost a defense to your consent. Maybe you've been in an accident, you hit your head. It's hard to consent if you can't see straight. Maybe you've been on medication of some sort. There's all kinds of ways we can use a defense to your consent. Okay, so that you weren't able to give legal consent because you didn't have the mental capacity at that time for whatever reason to give consent. So potentially the implied consent should be dismissed because it wasn't consent. You couldn't comply. Another one is, and this is very procedural, but I've had several cases dismissed on this, and that's on compliance with the statutory requirements by the police for implied consent to apply. And that could be the form could be wrong. Some of these agencies are using the improper form. It doesn't comply with statute. They're not reading the implied consent statute to you verbatim. I've had several where the cop just didn't read it to them right, and it gets kicked out because of that. They didn't have the proper times and signatures and things on it. It's just little procedural issues. So it's a procedural defense if they're not complying with the provisions of statute. And then here's the big one now, is if they're even constitutional. So there was a case, Birchfield v. North Dakota, that went before the Supreme Court. I think it was last summer, or maybe longer than that. I can't remember. I need to look at the date. Don't quote me on the date. But it's Birchfield v. North Dakota. But it didn't directly apply to like Tennessee law, because basically what it said is blood draws are unconstitutional implied consent. But it was specific to states where the implied consent violation is a criminal offense. Remember I said earlier, in Tennessee, implied consent is a civil penalty, all right? So it's not a criminal offense. It still carries the same kind of connotation, but you don't have jail time and stuff with it. It's just a license restriction. So Birchfield v. North Dakota said that no, blood draws are so invasive that, on the criminal side, you can't penalize people for not wanting to consent to a blood draw when you could just go get a warrant if it's in the context of criminal charges. Well, what's awesome is recently at the end of 2017, and it was actually September 14th, 2017, the Tennessee Criminal Court of Appeals had a case called State v. Henry. And in State v. Henry, basically the Tennessee Court of Criminal Appeals said they took Birchfield, even though neither party on that side, the state or the defendant of this was a DUI case that was on appeal. Neither one of them really brought up Birchfield v. North Dakota because they didn't really feel like it applied because of that difference in civil versus criminal. However, what they said in the case, the court just took it upon itself to go ahead and review Birchfield v. North Dakota. And when they applied it to Tennessee law, there's a couple of nuances here. So it's not 100% that they can't ask for the blood. But basically, they said that because the blood test is so invasive, it's a violation of your Fourth Amendment protections against unlawful search and seizure if the police don't have your consent or they try to do a forced blood draw or they try to use the implied consent as the violation to take your blood, and that you need to get a warrant. So what has been the result of that? Well, basically, the result is Shelby County, most of the agencies in Shelby County, Memphis PD, Shelby County Police Department, I know Millington PD does it now, they're getting search warrants. They're just not even worrying with implied consent anymore. They're getting search warrants. Now, why is that good for you? It's good because most police agencies around here don't know this. They're still trying to do the old, I'm going to read you the form and go take your blood. Well, on the defense side, awesome, because then we can get that stuff suppressed pretty easy now using this case law. It's relatively solid. I don't know that it's going to go up to the Tennessee Supreme Court, but the trend in all the states on DUI defense now with implied consent is this same thing, that it's unconstitutional to do the blood. Now, they can do breath. They can still do implied consent for breath, but a lot of agencies around here don't even do breathalyzer anymore. All they even ask you to do is blood. And if all they do is ask you to do blood, State v. Henry is going to be a good defense now that that's an unconstitutional draw. So what is the benefit? Well, if you suppress or get the implied consent dismissed, well, that means the evidence associated with it is suppressed also. So if they got blood evidence from you, that's potentially something we could dismiss. If you get that dismissed, and that may be the biggest crux of the state's case, and if you did well on your field sobriety, you drove relatively well, there may be very little evidence they have to show that you're actually under the influence of a DUI. So this implied consent change to where we may be able to get like blood draws suppressed based on violations of really constitutional violations under State v. Henry is a huge thing for DUI defense. So just real quick, because I forgot to add it, the other one last thing I wanted to address was whether or not you should submit to implied consent. And the lawyer advice is you shouldn't. That even though you're going to face a suspension of your license, you're just giving evidence. And I've addressed this in another video if you look at another DUI video. But that's kind of the general consensus. Now, on the other hand, if you know that it's going to come back and support you and show that there's nothing, well, that's something for you to consider also. So the standing rule is don't do field sobriety, don't submit the implied consent, but take that as you like. Anyway, I hope this was informative on implied consent. As always, please like the video, share the video, so information's power, and I want everybody to know. Again, we're not hiding the ball here. I'm telling the cops this is the way it is. If your prosecutors don't know, give them a heads up. I don't care. You got to change the game to comply with the law, and if you don't, it's better for me. It's easier then to defend some of these DUIs. And as always on DUIs, like I said, don't drink and drive. That's the first thing. Have a designated driver. Holla at me. I'll come pick you up. I've done it for other people. Please subscribe to the channel. I'd like to get the subscriptions up, and then give me your ideas on what else you'd like to see in the future. If you need to reach out to us at our law firm, the number's below. And hopefully you won't need me for that kind of thing, but if there's something else that we can discuss, I'd be glad to do it. So thanks for your time. Y'all be safe.